Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today, I'll be talking about impossibility of performance and frustration of contract. The entire topic of frustration is elucidated from the doctrine of frustration to effects of frustration as mentioned in the Indian Contract Act. Initial impossibility, Section 56. Section 56 of the Indian Contract Act 1872 begins by laying down a straightforward principle that an agreement to do an act impossible in itself is void. For instance, an agreement to discover treasure by magic because of its impossibility of performance is void. An agreement to do an act that is impossible from the beginning, whether the parties were aware of such impossibility or not, agreement will be void. Subsequent impossibility, Section 56. What if the parties enter into a contract and at the same time of entering it was possible to perform the contract, but due to some supervening reasons or factors beyond the control of either of the parties, the performance of the contract became impossible or unlawful? Agreements of such a contract are frustrated and hence void. For example, A agrees to sell a tract of land to B, but owing to some government policy, this tract of land has been taken by the government for some official purpose. The agreement stands frustrated and B cannot sue A for non-performance of his obligation as the performance of A's duty has become impossible. Doctrine of frustration. It is well known case of Taylor versus Caldwell. The defendants agreed to allow the plaintiff to use their music hall to conduct a concert for a few days. But before the performance of the concert, the hall was destroyed by fire without the fault of either of the party. The plaintiff sued for their loss. The court quashed their agreement, stating that the performance of the contract has become physically impossible because of the destruction of the subject matter, that is, the music hall in this case. This principle is not restricted to just physical impossibilities. It also implies to cases where the very reason of object why the parties entered into the contract fails to materialize. The well-established authority is Krell versus Henry. In this case, the defendants were keen on watching the coronation procession, so they hired a flat from the plaintiffs from June 26 to June 27. But owing to the king's illness, the procession was cancelled and the defendants refused to pay the money of the flat. The court held that the doctrine of frustration applies as the very object of the contract, as recognized by both the contracting parties, was to have a view of the coronation process. The happening of the coronation hence forms the heart of the contract. The very object of the contract was frustrated by the non-happening of the coronation, and the plaintiff was held not entitled. Commercial hardship. Sometimes there may be alteration to situations where performance is not practically cut off but only rendered more difficult or costly. Such cases do not fall under the scope of Section 56, and this is amply shown in the case of Sachindranath versus Gopal Chandra. In the case, the plaintiffs rented out the certain premises to the defendant for a restaurant at a rate higher than usual. The defendants agreed to pay a higher price, expecting huge profits as the British soldiers were stationed in the town. But due to the passing of the government order, the British soldiers were prohibited from entering the area. Because of this, no profit will materialize as expected. The defendants pleaded frustration and did not want to pay the rent. The court quashed their plea and said that the alteration of the circumstances must be as to upset altogether the purpose of the contract, and mere unprofitability cannot render the contract to be frustrated. In the Indian Supreme Court case of Ganga Saran vs Ram Charan Ram Gopal, where there was a contract of sale of certain quantities of cotton manufactured by Victoria Mills, Kanpur. This meant that the respondents agreed to procure cotton from the mill and sell it to the appellants. But owing to some issues, Victoria Mill was unable to supply cotton to the respondents, and the respondents plead frustration due to impossibility of performance. But the court held the respondents to be liable, stating that the performance did not become impossible as the respondents could have procured similar quantities from another mill and delivered it to the appellants. The mill does not form the reason of object why the contract was entered into. The object was to deliver certain quantities of cotton irrespective of the existence or non-functionality of the mill. In similar case of Harnandarai Fulchand vs Pragdas, the Privy Council famously held that the closing or even the destruction of the mills would not affect a contract. If there are more than one way of performing a contract and due to closing or destruction of a mill, one way is cut off, the party is still bound to perform by the other way of procuring goods from some other mill. Specific grounds for frustration. The doctrine of frustration is applicable to a great variety of contracts. It is impossible to lay down a straightforward list in which the doctrine applies and in which the doctrine does not apply. The law in this matter is always growing and evolving. Yet, there are few well-established situations recognized by the courts where the doctrine of frustration policies applies. Thank you.